make a motion, and I think I started to do so earlier. I'll follow through with it at this point. Make a motion and authorize counts 1, 2, and 3 of the indictment.
Mr. James, the way it's listed, count 1 is malice murder, count 2 is felony murder. You say count 3 is aggravated assault.
That is accurate, Judge.
Well, her trial starts Monday, but Andrea Sneiderman will not be facing murder charges. Yesterday, the judge approved the district attorney's motion to dismiss the most serious charges against her. Now, Sneiderman is charged in connection with the death of her husband, Rusty. Sneiderman's former boss, Hemi Newman, is serving a life sentence for the murder. The state had intended to argue that Andrea Sneiderman manipulated Newman into pulling the trigger. Well, Sneiderman is still facing several other counts, including perjury and making false statements. I'm joined now by defense attorney Mike Gottlieb and former prosecutor Tanya Miller. Both of you, thank you for being with me. Tanya, I want to start with you because we heard the district attorney say Friday, it would just be unethical, unjust to move forward with these charges. Is he being noble here, honest, or is this really about a lack of evidence?
Well, factually speaking, he's correct. It would be unjust and unethical for a prosecutor to proceed forward on charges that he does not believe the evidence would support. I think the question that many people have at this point is, at what point did you realize that you did not have evidence to support these charges? What changed from the time that you indicted Andrea Sneiderman for murder and today? And I think that is what is making people have that question. Okay, is this sort of a, we're kind of scared we're going to lose, we don't have enough evidence, or is this a genuine sort of assessment of the case and belief that it is unethical to go forward?
Yeah.
And I don't know that we'll know the answer to that
well,
anytime soon.
Well, it's interesting. We didn't hear about that on Friday. They didn't come out to the media. It'll be interesting to see if we ever learn the answer to that question. Mike, I want to ask you because, the judge denied a motion by Sneiderman's attorney to delay this case. They were looking for 6 months to all the way up to a year of a delay. Let's listen to that argument. I want to get your thoughts on the other end.
Well, the defense's request was that there's so much media attention. I'm sure that the media attention is not going to die down. I'm sure the judge sees that. In fact, if they continue the case for 6 months or a year, I think the media attention towards this case is only going to get bigger and bigger, and the judge sees that. It's going to be as difficult today as it is to pick a jury in a year, and the judge wants to get some closure to this matter and wrap it up and be done with, what the judge probably perceives as somewhat of a circus.
Well, let's listen, though, to Andrea Sneiderman's attorneys. They had an argument as to why it should be delayed. Let's take a listen to that.
I appreciate the fact that the state has stood up and said that they believe that it is appropriate under the circumstances to null pros counts 1, 2, and 3. Nonetheless, we are in a position where the state had previously presented to 3 different grand juries allegations of either murder or murder, felony murder, and aggravated assault. I just don't see how on earth she can possibly get a fair trial in the atmosphere that we now find ourselves in.
So, Mike, their argument, it's going to be impossible to find a jury that hasn't heard of Andrea Sneiderman. But the question is, in 6 months to a year, would that really change? You can't really, you can't unring a bell.
Not at all. I mean, in a small town, they seated a jury that hadn't heard of George Zimmerman. So, I think that case garnered a lot more national publicity than Sneiderman's case, and I'm certain that there will be people that haven't heard of her case or have heard of it and said that they can still be a fair and impartial juror. So I think they'll be able to get a jury regardless of whether it's now 6 months or in a year. I disagree with the judge's ruling, and I think that in a case like this, they should give the defense more time, but I think that the judge is right. You're going to get a jury no matter what. And
that jury selection begins on Monday. Tanya, we have this perjury case now, all eyes on those charges. What do the prosecutors have to prove, and how difficult would that be?
Well, essentially, for perjury, they have to prove that Andrea Sneiderman lied under oath, and those lies were material to the case that they were presenting against Hemi Newman. The question will be whether or not this issue of the affair and whether or not she had a relationship with him and when she was first notified about Rusty's death, whether those will be material. I think they are, and the question will be whether or not the prosecutors can prove that she lied about it.
And we'll start finding all those things out on Monday. Mike, Tanya, thanks so much for being with us, and don't miss a minute of HLN's coverage of the trial of Andrea Sneiderman. Jury selection beginning Monday.
How do you plead to the charge of aggravated murder in violation of Revised Code Section 2903.01A? How do you plead to that charge?
Because of the plea deal, I will plead guilty.
Well, There you have it. That move means Ariel Castro avoids a possible death sentence for holding 3 women captive for a decade. That plea agreement calls for life in prison with no chance of parole. Well, I'm joined now by defense attorney Mike Gottlieb and former prosecutor Tanya Miller. Thank you so much both for being with me. Tanya, let's start with you, because from the very beginning, this was such a grotesque situation. These victims, what they have been through for a decade, they really did not want to have to go through a trial, relive a moment of this. Have you ever seen a situation that's similar to this?
Oh, well, not factually similar to this, but certainly as a former sex crimes prosecutor and homicide prosecutor, I have had victims who have just not wanted to relive that crime because it was so horrendous over again in front of a jury and in front of the world. So it's not uncommon for prosecutors to have to deal with victims who really don't want a trial. And so when you have a situation like that, sometimes you're able to work out a plea agreement that is appropriate and that will save the victim from having to go through that. Sometimes you can't, and you have to go forward anyway, notwithstanding the victim's reservations. In this case, it looks like the prosecutors were able to get a really appropriate plea deal and save these victims from having to relive this.
Yes, some relief there for them. And Mike, as a defense lawyer, you know, it's your job. You have to defend whether innocent or guilty. You got to defend them as best you can. What do you do with a client like Ariel Castro?
You know, I think the first thing you want to do with somebody like Castro is you're saying, look, this behavior, it's not normal. So you would want to have him examined by a team of psychiatrists, neuropsychologists. You want to subject him to every examination you can and say, what made a person do this? It's not a normal thinking person. Clearly, he must have been insane. He must have been imbalanced. He must not have understood the difference between right and wrong, couldn't appreciate the nature and consequences of his actions, and get some doctors in there and evaluate him and see if you can give him a legally identifiable defense related to some kind of psychiatric illness.
Well, so it's interesting. Do you think that defense attorneys should have pursued insanity rather than taking a plea deal?
You know, I'm not sure that insanity would have worked, unfortunately, because when you look at somebody's activities and you want to say that they're insane, their activities should not be goal-oriented. And he did so many things that were goal-oriented. The barbed wire, the locks on the doors, you know, and those things suggest that he knew the nature and consequences of his actions. So I have to assume that his attorneys looked into that, and it was probably not a viable defense.
And Tanya, you know, the deal here, so to speak, was to take the death penalty off the table. What were some of the factors that go into determining whether or not that is something that is beneficial for your client?
Well, yeah, I mean, obviously, as a district attorney, you first have to make the determination of whether or not seeking the death penalty is appropriate. Most states have statutes that tell you what factors contribute to that, what factors must be present in order for you to do that. The district attorney signaled very early in this case that he believed that this case was appropriate for the death penalty, although he never formally sought it. As far as not seeking to formally put that death specification in the indictment, I think what the DA looked at was the particular situation of these victims, the fact that they had been held for 10 years and endured horrible, unspeakable acts, and that they did not want to testify about that in trial. So I think that played a big role in their decision.
Yeah, and we should also note a big part of this, you know, Castro never even will have the opportunity for a parole hearing. So this is life in prison, not even a possibility for parole. All right, Tanya Miller, Mike Gottlieb, thank you both for being with me.
Thank you for having me.